Welcome, everyone, to this edition of the Authors Guild Foundation series, Money Matters. We'll be discussing estate planning for authors. This is an important topic, not only to ensure that your creative work can benefit your heirs, but to ensure that your creative work is in the right hands. I'd like to note that the Authors Guild offers literary estate management as a service in cases where the copyrights are donated to us. That's something to consider. When we acquire a property, our lawyers can act as the executor, exploit the rights through republishing and licensing and film options. So if you don't have anybody who might want to look after your work when you're gone, or if you'd like your work to benefit the work we do in the future, feel free to get in touch with us for more information. And now we'll get to the good stuff. We're here with Erin Lowry again. Erin's the author of the 3-part Broke Millennial series, including Broke Millennial Takes on Investing, and Broke Millennial Talks Money. She's been featured in the New York Times, Wall Street Journal, CBS Sunday Morning, CNBC, The Rachel Ray Show. She's written for the New York Times, USA Today, and Bloomberg Opinion. Quite the CV. Erin, thank you for being here, and thank you to Ed McCoy for joining us. I'll turn it over to you two.
Well, thank you so much, and excited to be back, everyone. So today, instead of doing a panel discussion, we are having a seminar with Ed. So it's going to function slightly differently than those of you who have joined us for the panel discussions. Ed's going to go through his presentation, and then I'll come back on at the end and do a Q&A. So if you have a question, do not hesitate to drop it down into the Q&A below. Johnny and I will be monitoring that throughout the conversation today. And also, if you pre-submitted a question, I have pulled a bunch of those as well. So without further ado, let me introduce Ed. Ed McCoy practices law in Garden City, New York. He previously worked in the legal departments at McGraw-Hill Education and the Association of American Publishers, and as Director of Legal Services at the Authors Guild. Welcome, Ed. We're excited to have you.
Okay, thanks, Erin, and thanks, Johnny. So one thing that Erin told me prior to the webinar today was that there would likely be some people attending from outside of the United States. And so I want to let everybody know that this presentation is intended for a general audience. I happen to be licensed to practice law in New York State, so I will be giving some examples of New York State law by way of illustration to explain certain concepts. But those, again, are only examples, and you can talk to your on-the-ground trust and estates counsel in your state within the US or in the jurisdiction where you live abroad to see how the state or the laws of the foreign country might apply to pursuing similar strategies. So I want to start the presentation today with a hypothetical. And that is that I am a prolific author and I'm married and I have 3 children. So the second part is true, but I'm not a prolific author. So in my hypothetical, my wife predeceases me. She dies before me. And then I die and I leave behind my 3, and to simplify this, we'll say at that point in time, they're my adult living children. And in making my estate plan, I didn't do anything specific with respect to my literary estate. That is the copyrights to my books and other property that's part of my literary estate. And so what happens is, under my will, I've given some specific pieces of what's called tangible personal property to specific individuals. So certain valuables I give to extended family members that I know have some affinity for them. And then I leave my car to one of my sons and some other personal effects to the other 2. And then everything else in my estate, I give to my 3 sons in equal shares. That's called the residue. And the provision in the will that gives that is the residuary estate clause. And the consequence of that is that whomever I have named as my executor under the will transfers to my 3 children in equal shares all of my copyrights. And each child becomes a 1/3 tenant in common, a 1/3 co-owner of each copyright. So that raises the question, how is that going to work in practice? And I prepared a series of more specific questions in that regard. So first, who will take the lead in dealing with retailers, online services, publishers, and others with respect to my works? Who will manage my website and social media pages, paying server fees, renewing domain name registrations, and keeping the website and social media pages fresh and current? What happens when decisions need to be made of the kind that I make or I made every day during my lifetime as an author? Maybe the opportunity comes along to have a new edition of one of my books published by a new publisher. How is a decision reached as to whether to accept that offer? Maybe there's an opportunity for an introduction to be added to the new edition. Who is going to handle the vetting of the person selected or under consideration to be selected to write the introduction? Can contractual provisions be put in place to give the family a right of approval or at least a right of consultation with respect to the content of the introduction? How about royalty collection? It's true that oftentimes arrangements can be made with payors like publishers, where multiple individuals have come into co-ownership of the copyright to the work, to cut checks individually to each co-owner for the particular royalty statement, or to make those payments to the various co-owners electronically. Typically, for this to happen, a publisher collects an IRS Form W-9, which reports the co-owner's social security number to the publisher. Certain other paperwork is filled out, and then the publisher makes payments this way. Sometimes, however, royalty collection also involves, as many of you I'm sure have experienced, chasing down unpaid royalties or communicating with a retailer, distributor, publisher, or copyright licensing organization with questions about how the amounts on the royalty statements have been calculated. And then on the flip side of that, what about fulfilling any contractual obligations vis-a-vis royalties that I, as the author, may have had during my lifetime to, say, an illustrator or a co-author? And there might be circumstances where, if I've worked with multiple such collaborators, sometimes it's been arranged that I'm the party who initially collects the royalties from the payor, and then I have to account to and pay a share to that collaborator. Is one of my children going to stay on top of that responsibility after my death? Maybe arrangements can be made for direct payments by the paying company to the collaborator, but some companies' systems limit the number of payees to whom the company will cut checks or make electronic payments. And that could also, incidentally, affect the ability to make multiple payments to my 3 children. Let's say there was a novel that I had almost finished when I died, and not finished reading, but almost finished writing. Perhaps another writer can be brought in to help complete it so that it can be published. Well, who decides whether to do that? If it's pursued, who exercises creative control over the completion of the work? How is a decision made as to whether to self-publish the book or to seek a traditional publisher? And if self-publishing is pursued, who decides the self-publishing platform to use? Who selects the cover art? Who hires a designer to prepare the cover? If an archive at the university where I studied is willing to accept my personal papers, including my manuscripts. This would include the physical documents themselves, but not the underlying copyrights to those materials. So the boundaries within which the institution may engage in reproduction of the materials, such as by allowing researchers to access the materials in electronic format, remotely by way of internet-based technologies, or allowing a certain amount of photocopying by researchers, should be the subject of an agreement negotiated with the university. Who is going to handle those negotiations? Who is going to review the archive's policies and procedures with respect to access and copying by researchers? Going back to my published books, maybe I was lucky enough during my lifetime to get an agent for my works who was a great champion and secured numerous deals for me. But that person is now retired, and sales of the works have dried up. And the former agent's agency is still in possession of the exclusive representation rights to those works because of agreements that I signed during my lifetime. Well, perhaps there is somebody within the family or otherwise who can approach the agency and see whether the agency would be willing to voluntarily relinquish its representation rights with respect to those works, so that the family can pursue new representation or publishing opportunities directly. Maybe there are certain contractual rights to effectuate termination, either with an agency or with a publisher with respect to a book publishing contract. How is a decision reached as to whether to exercise such rights, and who takes the lead on pursuing that? So hopefully you're seeing the picture that I'm trying to paint here, which is that in certain situations, it may be much more workable to have one person in charge of all of these responsibilities, even if you want multiple people to benefit financially from the production, distribution, and sale of your works after your lifetime. The other point that I'm trying to make with this list is that it's a lot of work. So in your estate planning, specific to your literary property, as opposed to your general property that you own, you might consider establishing what I call a literary trust and naming an individual person to serve as the trustee of that trust. The trust would be called the literary trust, and the trustee in charge is the literary trustee. I'm going to talk about that concept in more detail in a few minutes, but first, I'd like to discuss what the property might be in total that comprises your literary estate. So this is a sample list for one possible author. All copyrights to your books and manuscripts, whether published or unpublished, completed or not completed. Any trademark rights you may possess to a book series title, where you've written a book series during life and the title of the series has become popular and enjoys trademark protection. All rights to any other writings you've created during life, such as poetry, articles, blog posts, screenplays. Rights to any adaptations or derivative works based on your books, which could include things like audiobooks, merchandise such as apparel or games, foreign language translations, graphic novels, television or stage adaptations. And this would include not only your rights with respect to such works created during your lifetime, but also the rights to authorize the creation of new derivative works after your death. And if we refer to all of the foregoing as your creative property, you can expressly give all of your rights under any licensing agreements you've entered into with respect to these works, including but not limited to the rights to receive royalty payments. Furthermore, you can expressly give the rights to enter into new contracts and issue new licenses. Now, I think those contractual pieces are part and parcel of the copyrights that you would be giving, but I do recommend spelling it out, because when your fiduciary, say your executor or trustee, or an outright beneficiary of your literary estate goes to a trading partner like an online bookseller or a publisher and says, hey, I stand in the shoes of the author now vis-a-vis this contract, the company might require proof of that, which could be shown with the particular provisions of your estate planning document that gives those rights to this new person. Your literary estate can also include your digital assets relating to your creative property, including domain names, the content of, accounts for, and rights to administer your websites, blogs, social media pages, and accounts with online book retailers and distributors. And then also documents and records pertaining to your literary property, either in print or digital form, such as manuscripts, print or ebook production files, which you've used for self-publishing and you've retained, publishing and other agreements, correspondence with parties with whom you've done business, marketing materials or plans, usernames, passwords, or other authentication to access any of these materials that you've left behind in digital format, as well as to access accounts with online retailers and book distributors. I recommend collecting all of these materials together in a unified location. So with regard to print materials, perhaps a set of file drawers or boxes, or when the materials are stored digitally, maybe a thumb drive or a dedicated folder on your personal computer, but in all instances, clearly labeled as being intended to be given to the person to whom you're giving your literary estate under your estate plan. Separately, there may be some physical items you would like to give to a research archive, such as at an institution of higher education or a community organization willing to accept those items. Your estate plan would make clear that this would be separate from the underlying intellectual property rights in such materials. You'd only be giving the materials themselves. And such physical items that you could leave behind might include, again, manuscripts, letters, research, and any other physical materials that you clearly label as being intended to be given to such archive. Finally, you can give as part of your literary estate your ownership interest in any business entity you may have established in connection with your writing, such as a single member LLC. So how do you establish a literary trust? Well, there are two ways that I'm going to talk about. One is under your will. So you could retain all of this property during your lifetime, and then in your will specifically give all of those assets to a person you name to serve as literary trustee. And then the will also has provisions establishing the literary trust, describing the powers of the trustee, and the trust comes into being after your death. Another way is to bring the trust into being during your lifetime as a revocable living trust, or I'll sometimes call it an RLT to make clear that I'm saying a revocable trust and not an irrevocable trust. So revocable living trusts are often used for other types of property where a person making their estate plan is trying to avoid probate. Now, if you'll stay with me for a few minutes on this, I'm going to toggle back and forth between wills and trusts. So probate refers to the process whereby a will is, so I'll use New York State as an example. Somebody dies with a will. They have nominated an executor in their will. They've named a person whom they want to serve as their executor. That person works with an attorney after the testator's death, after the death of the person who made the will. The nominated executor works with an attorney to prepare and file a petition with the surrogate's court in the county where the testator was domiciled when she died, the place where she had her primary residence when she died. And the petition asks the court to essentially do two things. One is admit the will to probate. So the original copy of the will is filed with the court. The court inspects the will and is asked to make a determination that the will is valid, that it was executed in conformance with the requirements of the state statute governing wills. So in terms of the formalities, and that the testator was of sound mind. When she made the will, she understood the nature of what she was doing. Nobody was forcing her to do this, and so on and so forth. Secondly, the court is asked to formally appoint the executor nominated under the will. So to issue what are called letters testamentary, which empower the executor to collect the probate assets, that's the assets passing under the will, to use estate assets to pay any income taxes due on the decedent's final income tax return, or any fiduciary income tax returns that have to be filed for the estate for any income the estate has after the death of the testator, to pay other debts and expenses, administrative expenses, a commission to the executor, and ultimately to make distributions to beneficiaries in accordance with what the will provides. So people will sometimes use a revocable living trust to try to avoid probate because they anticipate some difficulty that could arise from probate. A classic example in New York State is we have a lot of people who, when they get older, they go down to Florida for a few months, maybe right after New Year's, and stay into the early spring. And so we'll sometimes be able to purchase real property in Florida when they go to stay down there. And if the Florida real estate passes under the person's will when they die, and they're still domiciled in New York when they pass away, then two proceedings will be needed. One for the will to be admitted to probate and the executor to be appointed in New York, and then a second proceeding called an ancillary probate proceeding in Florida to authorize the executor to collect and administer the Florida property. So for instance, if the will authorizes it for the executor to sell the Florida property and distribute the net proceeds of the sale to the beneficiaries under the will. So that creates additional expense for the estate because you have to pay filing fees for the proceedings in two states rather than one, and you have to pay legal counsel in both states to help bring the proceedings. Another reason people may try to avoid probate is that they anticipate a possible will contest by a disgruntled family member who is entitled, over whom the court needs jurisdiction in the probate proceeding, but who maybe was left out of the will, or got less than other people. And so a revocable living trust works differently. With a revocable living trust, a person who in New York we call the grantor or settlor sets up the trust by signing a written instrument called a trust declaration or trust agreement. And typically will assign himself, will nominate himself, well, he will be both the beneficiary of the trust and the trustee of the trust during his lifetime. And so we'll manage, we'll set up the trust, and then we'll, for example, if there's, in the case of the Florida real estate, would deed the Florida property from himself as an individual to himself as trustee of the trust. And we'll do the same thing with other properties such as bank and brokerage accounts, personal effects, and other property. The individual, because the trust is revocable, will have total control over the property in the trust during life. So is free to put property in, to take property out, to withdraw principal and income at any time and in any amounts, to change the provisions of the trust document, and even to shut down the trust altogether. And for income tax purposes, the revocable trust is essentially inseparable from the individual who sets it up. So any income of the trust is treated as income of that person and gets reported on the grantor's personal income tax return and is associated with that person's social security number. There's no separate taxpayer identification number for the trust at that point in time. It's only when the grantor dies that the trust becomes irrevocable. And at that point, its provisions are set and a successor trustee named to step in either when the grantor becomes incapacitated or at the time of the grantor's death will then complete the administration of the trust, which could mean paying estate expenses, trust expenses, income taxes, and so forth, and collecting commissions and then paying out the balance to a named beneficiary or more than one named beneficiary and closing down the trust. Or could be directed to continue to hold property in the trust, for one or more people. And so that's what I'm talking about here. So if you set up, oh, and importantly, when it's a revocable living trust, once the person dies and the trust becomes irrevocable, there's no need for court involvement in order for the successor trustee to administer the trust property. There's no court proceeding that needs to happen. So with the example of the Florida real estate, the trustee immediately administers that real estate without having to petition a court first for authorization to do so. So at least in New York, you can set up multiple revocable living trusts for different property. Usually when a person has such a trust, it's for all of their property. But literary property is unique, and we're talking today about specific things that would be done by a fiduciary of a literary estate and how that would be handled with respect to beneficiaries. So you could have, if you were one of these people who wants to avoid probate for a good reason, you might have a revocable living trust already, or maybe that's what you're planning to set up, but you could have a separate revocable living trust, which you fund, if you will, exclusively with your literary property. So your copyrights and the other items that I mentioned earlier in the talk. Somebody, Erin also mentioned to me that somebody had raised the question, well, you know, most trust and estates lawyers don't have expertise in copyright and book publishing. And I need to be mindful of my budget. So can I just in my general revocable living trust for whatever property that person might have. Again, maybe it's a house, financial accounts, and certain other things that the trust gets funded with. Can I also move my literary property into the trust and just leave it at that? Now, that's possible, but I think in many cases it makes sense to have separate provisions in the trust instrument where, here's one example. You could put your literary property into the trust during your lifetime and then have the trust document provide that when you die, the specific property comprising your literary estate, separate from your other property, will be given to a person named in the trust document to be the trustee of a newly created subtrust called your literary trust after your death. Now, with regard to the question of expertise of trust and estates attorneys, this is an area where I've been able to be helpful in a number of instances for Authors Guild members who reside outside of New York State. So in states within the US outside of New York. As I mentioned earlier, I'm licensed to practice in New York. I work on estate planning and administration matters every day, but I am not licensed to represent people and advise people on trust and estates law outside of New York because the laws of those states will be applicable. So what we've been able to do in some cases is the person has their on-the-ground trust and estates counsel in their particular state, and I've been able to serve in exclusively a consulting capacity to the author and their attorney. So providing some recommendations, drafting language for review by the author and their lawyer, and then trust and estates counsel ensures that the language, if incorporated into the larger document, will comport with state law. And also, I am mindful of the fact in those situations that the author is having to pay their trust and estates counsel, so I do try to keep the consulting fee within reason so it's palatable to the author. Okay, something that the trust document can direct the literary trustee with regard to is how often royalty payments get distributed to beneficiaries. So one way to set this up could be to direct that each year, each calendar year, the trustee use trust assets, will collect all royalties, licensing revenues, any other revenues coming into the trust, deposit them into the trust bank account, use assets in the account to pay any expenses like paying accountants to help prepare and file the trust fiduciary income tax returns, paying for any legal counsel that might be needed from time to time, more ordinary day-to-day expenses like purchasing shipping materials and paying for courier services and doing other things regarding shipment of books and other tasks. And then the trustee paying a commission to herself, maybe then that could be compensation that is defined by statute. So in New York, we have Erin had a quick question from Erin is whether she can tell everybody that this will be posted on YouTube within a couple of weeks. Yes.
Yeah, sorry, Ed. Did not mean to interrupt. I was speaking to Johnny. We've got a ton of questions about whether or not you'll be able to rewatch this, and you absolutely will. I know there's been a lot of frantic handwriting and questions, so this will absolutely be available for you to consume, usually about a week until it gets uploaded onto the Authors Guild YouTube channel. So do not stress, you will be able to rewatch this content.
Okay, thank you. All right, so I'll be watching as well to see how I did. But okay, so I was saying that one of the other things that can get paid out of the trust account would be compensation to the trustee. Now, the relevant state may promulgate by way of statute by default what a trustee's commissions are if the trust instrument doesn't specifically define the commission. So you could include something different, like a 15% commission on all revenues of the trust, either from royalties or interest on the trust account or otherwise. So because what the trustee is doing is kind of like what a literary agent does in some respects. But that's totally within your discretion as the person setting up the trust. Okay, and then after, so what I was saying was the trust document could provide that after all of those expenses are paid, once a year, the trustee will pay the balance of the revenues out to named beneficiaries. So going back to my original example, maybe I do this and I make the beneficiaries my 3 sons. And by the way, the trustee could be one of them. The trustee isn't precluded from being a beneficiary if that's the way that you want to set it up. In the alternative, you may want to give the trustee discretion. So in the first instance, the trustee should probably be able to hold on to some reasonable reserve so that there's some money there for ongoing expenses until the trust account is sufficiently replenished with new royalties. But otherwise, you could say the rest of the monies go out to the beneficiaries at some set point once a year. Another way perhaps to do it is to give the trustee wide latitude, complete discretion as to how often to pay out principal or interest or income in the trust to beneficiaries and in what amounts. So we're coming up, I think I've got about 3 minutes left before the 2:40 mark, and I'm supposed to wrap up my prepared remarks by then. So a couple of things that I will add quickly is that under a couple of sections of the US Copyright Act, one being Section 230, which applies to grants of copyright interest since 1978, authors have, during their lifetime, statutory termination rights a certain period of time after signing a contract to grant copyright interest to a publisher or other licensee, or within a certain amount of time after first publication of the work pursuant to that grant. Now, I'm not going to be able to get, with the time left, I'm not going to be able to get into that into detail, but I want to note that you can't necessarily, you can't give termination rights under your will or trust to people after your death. So if the window is still open to serve a termination notice for statutory termination, then the Copyright Act defines the people who would come into the possession of those termination rights after your death. And they include some combination of a spouse, children and or grandchildren, or if you're not survived by any such people, then the fiduciary in charge of your literary property, such as your executor or trustee or administrator. And finally, when you're talking to legal counsel about creating your estate plan, whether it be a will or a trust, it's very important to have specific provisions empowering your fiduciary, as well as any outright beneficiary of your literary estate, to be able to access your digital assets. So this is email accounts, accounts with booksellers, and then getting away from literary property for a moment, your online banking, anything like that, because otherwise the online service provider might very well refuse to give access for fear of running afoul of federal or state laws governing unauthorized access to computerized information, as well as online privacy, and will sometimes require a court order in order to do that. So having this type of language in your estate planning document can either persuade the online service provider to give the requested access and control, or persuade a court to order that, and will also be instructive to the court as to the scope of the order. Okay, so thank you for listening, and I look forward to the questions and the discussion.
Well, thank you, Ed. We have had a flurry of questions, so we have a lot to try to tackle in the next 20 minutes. I do want to reiterate for everybody tuned in, you will be able to see a video of this webinar probably in about a week. It will get uploaded to the Authors Guild YouTube channel, so you can definitely go back and rewatch. Now, one of the questions, and I know you did dig into this, but I wanted to just push at this point again. And you mentioned that we did have that question ahead of time about literary estates feels a little bit out of my budget. We already have a family trust. And to that end, we were also asked, are general clauses in a will, which assigns a spouse ownership and authority over the descendant's literary works, generally sufficient? Now, you had mentioned that you encourage the separation of the two, but if we're looking at a budget restriction or otherwise, is it possible to kind of lump this all into one general will?
Yeah, so it's certainly something that you can do. And as an immediate concern, it might work just fine. So if you're married and you're survived by your spouse, and you give everything to your spouse under your will, which is what people usually do if they're married in their will. If your spouse is prepared to manage your literary estate, because at that point they'll become the sole owner of it, then that'll work fine for so long as your surviving spouse is living. But in order to ensure longevity of the management of your literary estate, your spouse would then need to have in their own estate plan provisions for how your literary estate is to be handled. So one thing that perhaps could be done is you and the spouse would each have in your wills provisions that you give everything to one another, and might provide that after the second of you dies, a literary trust will be set up at that time as a testamentary trust. And the family composition where a person is married is also a factor. So if you have a spouse and one child, then you don't have the complications arising from the example I gave with having 3 children. But at some point or another, there's no longer going to be, most likely, one individual who would be given the entire literary estate. And so how do you ensure one way or another that somebody's going to manage all of this and keep your literary legacy fresh and active and generate revenues and provide financial benefit to as many beneficiaries as there might be at that point in time?
Well, thank you for that. And on the idea of if you separated, you have a literary trustee, but if you predecease your spouse, does your spouse have any right to override the trustee's decisions?
Well, depending on the state you're in, there is something called a right of election in New York. So a surviving spouse in New York can defeat an estate plan so as to be able to take outright 1/3 of an estate. So something like that could come into play. But if you're concerned that your spouse would be dissatisfied with how things are going with a literary trust, you could name your spouse as a co-trustee after your life. You could name your spouse as the trustee. And one point I want to make about trustees is it's not as if you appoint one person and that's the end of the inquiry, because a literary trust could conceivably last for another 70 years after the lifetime of the author, because most copyrights nowadays last for life of the author plus another 70 years. So you want to nominate a trustee to serve after you stop serving, but you also want to name one or more successors in case that person dies themselves, becomes incapacitated, maybe moves away, is unavailable to serve. And then eventually you'll get to a point where there's no named successor to act. So it's good to have provisions empowering an acting trustee after all of those nominated people have been given the opportunity to serve, to name a co-trustee or a successor trustee. And furthermore, you can provide that if there is no acting trustee, that certain people, such as a majority of your adult living beneficiaries at that time, have the power to appoint a successor trustee. Now, with the 3 children example that I gave, I might provide that when I die, a literary trust gets set up for the benefit of my wife. And then after her, the beneficiaries are to be my 3 children. And then if any of them dies, a sub-share is created. So their share gets divided among any children or other issue they have, and then their children. So it can go on through the generations potentially. So you do need provisions in place to ensure that somehow there's always a means to put in place a successor trustee.
Now, we've mentioned a lot spouse, children in terms of this conversation, but there are plenty of authors who are single or unmarried and do not have children. So in those situations, what are planning considerations for them to think about?
Oh, absolutely. So I think most of what I said is exactly the same, but in place of a surviving spouse or children, you would consider extended family, perhaps friends, perhaps charities, nonprofits. So one of the key things when I have estate planning clients come in and they're not married and they don't have children is we have to determine very carefully who's in their family tree, because when the person dies, if they're making a will, the probate court needs jurisdiction over certain family members depending on their degree of blood relationship to the person who died. So we take down information about potential distributees, as we call these people, including their names, their addresses, any children or other issue they have. And that's all stored in the client's file so that one day the distributees for the purpose of a probate proceeding can be identified. But otherwise, I would say that everything I'm saying is generally the same.
Now, there's been a few questions about how do you find this person? So when you're thinking about picking a literary executor, are we focusing on experience with your kind of work, their age, their career? Your family members might not understand the literary world. So how can we vet someone? Where should we go to even do this research in the first place?
Yes. Okay, so the first thing I would say is regarding book publishing expertise, knowledge of how publishing works, that is something that's great to have. It's certainly valuable. But as a threshold matter, the most important thing is finding somebody who is going to be willing to put in the time. So they have to be your champion. They have to be out there trying to build new readership, find opportunities for your works, manage the contracts and publications that you have in place. And this can be a significant challenge. There's not always an obvious person to do this. If you can get somebody who's enthusiastic and willing to take on this role energetically and also has book publishing knowledge, then that's a home run. That's wonderful. But I don't see it as mandatory. I think the most important thing is, and perhaps the harder thing, is to identify somebody who's going to be willing to do this. So a lot of the time it is somebody in the family. It might be a writing colleague. Conceivably, it could be your literary agent, although my only concern there would be how long will your agent hang in if there's a dip in sales, and obviously they have to make a living, so they have to justify things financially. Also, I hadn't had a chance to mention earlier, but for a number of literary estates, the Authors Guild is actually now the owner of the literary property, because the Authors Guild member gave their literary estate to the Authors Guild at death. So there, the Authors Guild is acting sort of like a literary trustee, except that it's doing it as the owner, so is keeping the revenue, or the foundation is keeping the revenue from the sales of the works. And I have had some conversations with the Authors Guild leadership about whether the Guild could perhaps at some point take on more literary estates where the guild was taking some piece for its own administrative costs, but then also paying some share out to beneficiaries like family members. Now there, I think the projected revenues from the literary property would need to be sufficiently substantial so that the Authors Guild could cover its costs. But it's something that I know the organization has looked at, and you could inquire with the Guild about this possibility.
Now, if we think about authors who are either earning very modest royalties, or perhaps their books, even though they own the copyright, the books are out of print, or it's not necessarily an evergreen topic, there are a few questions around, do I really need this set up if I'm not sure about the longevity of my book?
Right. So it's still possible. It's just that if you're going to do it as a trust, whoever serves as trustee would have to be willing to do it as a labor of love and not be compensated unless and until such time as sufficient revenues were generated so that the trustee could be paid something and monies could be paid out to beneficiaries. So that's something that you have to think about. Sometimes an outright gift of the property under your will or trust might make the most sense. But again, we want to think about the longevity of the material. And you never know. You never know with copyrighted works. Something can always come along to bring the work into the public eye and can even be a windfall financially. So if you give your rights outright, you could talk to the beneficiary currently and say, you know, when you come into the possession of these rights, you need to eventually have a plan for what happens to them after your life.
Now, do you recommend that we all tell, whether it's our editors or literary agents, who the executor is, or is that something that will just get triggered in the event of a death?
Well, that's why I recommend giving this, I talked about sort of a document file, so that whoever is going to manage these assets after the author's death knows whom to contact. So here's a list of publishers, and here's contact information for the editor that I work with over there, and all that sort of information. I think that's sufficient, especially because an estate plan can always be changed by the author at some point during life, and it might make the most sense to wait for that person to be notified until it's done by the person who actually comes into possession of the literary estate.
Now, I know you touched already a little bit on unpublished works and what can happen after your death, but somebody also brought up the idea of things like confidential interviews and other things assets we may have been protecting during our lifetime, and ensuring that those stay protected upon our death.
Yes. So yeah, with regard to materials such as that, you want to give specific instructions to your fiduciary or beneficiary as to, if you want something not to be published or otherwise made available to other people, you can give specific direction about that. If instead you want to give discretion to that person as to what to do with such material, you could do that as well.
Now, there have been a variety of people who have mentioned or are interested in donating their works after their death. And one question was, I'm donating my career work, books, manuscripts, research, etc., to a library. How can this affect my literary agency agreement?
Okay, so if you have a written agreement with the agent, the agreement may discuss which works are covered by the representation, what territories, what media and markets. So if you do have a written agreement, that would be one place to look, and consider whether the material that you're interested in giving to the library, if in some way that could be seen as overlapping with the agency's representation. Now, on the one hand, usually when you give to an archive, you're just giving physical material, and in the case of a library, people could come to the brick and mortar library and look at what's there. And if there's a remote component where people can access library holdings online, that could be rather restrictive. So there might not really be a problem, but it's probably worth approaching the agency and discussing what it is that you want to do and seeing how they respond. And perhaps while you're engaged in any such communications, keeping the Authors Guild apprised and getting some guidance from the Guild as you go regarding crafting your communications and responses.
Now, I know you've mentioned that you should have more than one person listed to be an executor, just in case for whatever reason person one can't do it. But can there be multiple people at the same time who are functioning in the role of executor, or is it only allowed to be one?
Yeah, so when you're talking about either a trustee of a trust or an executor under a will, you can have more than one. So that would be called co-trustees or co-executors. And sometimes that's really helpful because one person might have expertise in, say, somebody with expertise in publishing, and then somebody who has a lot of energy, and the two will work well together to make things happen and to do things correctly. And with executors, I had mentioned the literary executor could be a co-executor who specifically manages the literary property passing under the will until such time as that property is transferred to the literary trustee or the outright beneficiary or beneficiaries. One thing that people have to be cognizant of, however, is that a fiduciary is often entitled to commissions. So if you have two co-executors, absent some language in the will stating otherwise, they'll both be entitled to a commission. So that doubles the amount that has to be paid. And same thing with regard to co-trustees. But that can be managed by speaking to it in the will and perhaps specifically defining each person's compensation. So the short answer is yes, absolutely.
Now, we've had a variety of questions that I kind of feel are, can we bypass doing the will is sort of what my feeling is on the question. But a big one has been, if I have a revocable living trust, do I still need a will? Or alternatively, if I already have my royalties flowing into a living trust bank account, do I really need to take further action?
Well, one general point that I should make about revocable living trusts is typically when you have an attorney prepare the trust document for you, you also have them draw up what's called a pour over will that you also sign. So that's to ensure that when somebody's trying to completely avoid probate for their house and any other real property that they own and their bank and brokerage accounts and anything else, if they miss something and don't move it into the trust, then it might have to pass some other way. And if they don't have a will, it would be the subject of what in New York we call an administration proceeding, where somebody dies intestate without a will. So a pour over will provides that any assets passing under the will get poured into the trust at death, and then the trustee administers them the way directed in the trust instrument. So regarding the other piece of that, whether to just have royalties paid into the trust, you'd also have to think about, okay, well, then, what do we do about, do we give the trustee specific powers relating to the literary property, like I had talked about before? How long is this trust going to last? If it's a living trust, how long does it last after the author's death with regard to the literary property? Do we want the trust just to be wrapped up and the literary property distributed to some beneficiary, or do we want it to continue on? So those would be key questions.
We have one more minute left, and final question, based on all of your years of work in this field, what is one common mistake that you see getting made that if we could do one actionable thing today after leaving this webinar, you'd be like, yes, please go do this?
The biggest mistake is not to make an estate plan, which sometimes happens, because then everything passes. In New York, it would pass in intestacy, and then state statute will govern everything that happens to property that you haven't otherwise disposed of. So estate planning is really important. And I tell people too, it's empowering because it may cost something, but that it puts you in charge, and then you can rest assured that things are going to happen the way you want them to after your life with regard to the disposition of what you own.
Well, Ed, thank you so much. And I'm going to tag on there and also say, I believe estate planning is one of the greatest acts of love you can give the people in your life. And even that doesn't have to mean a spouse, that doesn't have to mean children, that can also mean just your overall community and loved ones and people that care about you. So it's something that they're not stressing about in a grief-stricken situation. Now, Ed, thank you again so much. I also do just want to make note, it's been said in the comments, Johnny can tag on here, but the Authors Guild does have an option that you can always leave your literary property to the Authors Guild and they can administer the literary estate. Johnny can clarify a little more. You can also feel free to email the Authors Guild and ask for more on that. Thank you all very much for tuning in.
Thanks so much.
Thank you, Aaron. Thank you, Ed. And everyone, remember that we have another webinar next week on retirement planning with Aaron. So we're looking forward to that. In lieu of spelling my last name for you, I'll just say you can email support@authorsguild.org with any questions, and I'll be reviewing the Q&A to see any unanswered ones that we might answer in the future. Thank you. Thanks, Ed. Thank you, Aaron. Thanks, everyone, for coming.
Thanks to you both, and thanks everybody who attended.